time. So if I initially could start by turning over to Anna and to Keith just to introduce our topic and their organisation.
Yeah, thanks very much, everyone. It's nice to be here. Just a little introduction to us. First of all, we're solicitors from A&L Goodbody. A&L Goodbody is a law firm with offices based in Belfast, Dublin, in London, and also in the US. And we focus, one of the areas of focus for us as a firm is on cybersecurity, data protection, and regulatory investigations. And that's sort of the focus where we're coming from today. We're both from Belfast. We sit in the Belfast office, which has around 130 lawyers and support professionals now in the team. So we're a growing team, and this is right in our space. So it is. Over to you, Anna.
Hi, everyone. Great to be here today. My name's Anna Cartwright. I'm a senior associate in A&L Goodbody in Belfast. I specialise in corporate law, and I advise a wide range of businesses in different sectors, and particularly technology and IT.
Yeah, and I am Keith Dunn. I'm a senior associate as well in the firm. I work in the commercial team, the commercial and technology team, with a particular focus on commercial contracts, cybersecurity, and data protection.
Brilliant. And Keith, thank you so much. Introducing myself, I'm Ben Harrison. I'm one of the organisers of NI Cyber, and also on the call we have Gillian and Joe, our cluster manager Joe, and Gillian, who's one of the other organisers. My background is cybersecurity. In my day job, I've recently started a cybersecurity startup, but have 20, 30 years experience in the industry talking through these topics. So to introduce a little as well about NI Cyber, for those who don't know who we are, we're the local UKC3 recognised cybersecurity cluster. Our mission is very clear. We're here to help support all of the organisations associated with and involved in the ecosystem of cybersecurity in Northern Ireland. That includes business, it includes community groups, it includes academia, and includes cybersecurity professionals. So thank you for joining this session, and we look forward to hopefully seeing you at some of other events in the future, such as our cyber breakfasts, which are the last Thursday of every month, and our tech and tipples, which are quarterly. I think we're going to just jump in straight into the topic. So if I could ask first up, Keith, why was the CRA actually needed?
Yeah, this has been a bit of a journey over the last few years, Ben. The European Union has been increasingly concerned about cybersecurity and the risks posed by cyber attacks within the European Union. In 2020, it produced a report called the EU Cybersecurity for the Digital Decade, and it basically set out a plan for how the European Union was going to respond to the threat of cybersecurity. And it's seen it as a very significant threat. By 2021, it estimated that the cost of cybercrime was in the region of 5.5 trillion euros. So it was an enormous problem, and it was only going to get worse as more and more products became connected. Particularly with the Internet of Things, we're seeing just products becoming connected and part of the cyber world. So the European Union looked at it from a financial perspective. They also looked at it from other perspectives as well. So consumer safety, very concerned about the consumer's safety aspect of some of these products, public health, but even more fundamentally, the European Union was very concerned about the cybersecurity threat to democracy itself and the democratic institutions underpinning the European Union. So it's seen this as a very big threat, and it basically felt that it had to act. And so the Cyber Resilience Act is the result of that, of years of thought and process and a reaction to what it perceived was a bit of a patchwork of legislation throughout the European Union, where member states were sort of forging their own path. Now we've got a consolidated version, consolidated piece of legislation, which will apply across the European Union.
Yeah, that makes total sense. And we were chatting before, and you folks had reminded me at Christmas time, we had an NI Cyber Tech and Tipples, where we deep dove into some of the devices you probably don't want in your home. And it was a play on words of, it was the night before Christmas, and all through the house, nothing was stirring, not even that 3G gaming mouse you bought your kid, which is stealing all your data and sending it to foreign nation state actors. And that's really without trying to put the fear at it, that's what this act, I understand, is to deal with. It's the fact that we have this uncontrolled wild west of devices that we're happily bringing into our homes, bringing into our businesses, and effectively they, in many cases, are proven infiltrators. They do things like run Tor nodes, they act in botnets, and all of this is unregulated. So it's really good to hear that the governments in different regions are working on that. If I could maybe jump along a little bit from that, Anna, so the history of this and the current status, where does the law currently sit?
So, as Keith said, in 2020, the EU institution published this cybersecurity strategy for the digital decade. And in that, there were calls for a harmonised piece of legislation for harmonised rules across the European market on cybersecurity for connected devices. What then happened was the draft proposal for the Cyber Resilience Act was then proposed in September 2022. And at that stage, it started to make its way through the EU's legislative process, as you can see on screen there. Where it sits now, it has been adopted by one of the two EU institutions. That happened in March. We're waiting for the European Council to also adopt it. At that stage, and I should say we expect that to happen in the next couple of months. At that stage, it will be published in the EU's official journal, and the Act will come into force across the EU 20 days later. But I suppose the question that you'll be wondering is, when do the obligations actually kick in for me? The general answer to that is 36 months after the Act comes into force. However, there will be some provisions which come into force earlier than that. For example, the obligations to report known vulnerabilities or cybersecurity incidences, that kicks in 21 months after the Act comes into force. So in general then, we can say that by 2027, at some point in 2027, all of the obligations of the Act will be applicable. Now, that might seem like pretty far away, but I suppose in practice, any products which are being designed and planned now for launch in 2027 will be, if not already, in the planning stage now. So it's something I think that preparation is key here. And I mean, it's a very new piece of legislation. It's not yet in force. And as is the case with all sort of significant milestone pieces of EU legislation, there will be guidance about this, and we'll see that coming out from the various institutions and other sources. So something to keep an eye on, very much so.
Thank you very much. And speaking as someone who's building a product right now, 2027 sounds like it's very far away. It's really not. And blink twice and we're standing there. So it's good to hear that there'll be guidance coming out in advance of that. Keith, if I could maybe ask a little more about the context of the CRA, maybe in a bit more detail, but things such as where and how it sits in relation to existing certifications, and the rest of the legislation in this area. I mean, for example, for years in the security industry, we've had sort of a crossover between SOC 2 type, which is mostly sort of US based, and then the ISO 27001, and they don't quite sit on top of each other. So how does that work with this Act?
Yeah, so looking at regulation, first of all, I'm very well aware I'm talking to a room full of IT professionals. All of these pieces of legislation that you see on the screen are ones that you'll probably be familiar with. And I think the point is that the Cyber Resilience Act is like one piece of the jigsaw. The European Union has been progressing various pieces of legislation over the past few years with a view to try to increase security across the EU internal market, to increase competition within the market, and just to make it a more transparent place for businesses to do business. So these pieces of legislation are all sort of part of the wider picture, and the Cyber Resilience Act is one piece of that jigsaw. So if you think of the AI Act, it regulates the use of artificial intelligence and entities that use it. You've got the Digital Markets Act, which prevents large companies from abusing their market position. You've got the Digital Services Act, which deals with illegal content, transparent advertising, and disinformation on online platforms, very relevant at the minute with elections ongoing. And then you've got the NIS2 directive, which deals with cybersecurity within specific important sectors such as energy, transport, health, finance, etc. So you've got all of these pieces of legislation. And what we're seeing is the European Union is looking at cybersecurity in the round, and they're trying to increase standards, trying to make services and products more secure. And the Cyber Resilience Act focuses specifically on what we'll come on to as products with digital elements, and we'll come on to explain that in a moment. You mentioned there, Ben, just about certifications and standards. And it's a really interesting topic because we mentioned at the start that member states have been sort of forging their own path for quite some time in this. And it actually was industry was pushing cybersecurity to some extent and trying to agree a commonality across the providers, and agreeing certain standards. And so we had, you mentioned SOC 2, we've got the EN standard, ISO, we've got ISA, all these various cybersecurity standards that have been pushing forward and trying to allow businesses, manufacturers to showcase their products as being cybersecure and maybe better than other products that are on the market. And I think regulation has been sort of piggybacking on that to some extent. And we see that the Cyber Resilience Act is actually using some of the standards and some of the path that has been forged already by industry in incorporating and developing the Cyber Resilience Act. So that's been really useful and really helpful. In terms of looking forward, Ben, I think these certifications and standards are going to continue to be relevant because we're now moving into a regulated space with penalties and enforcement possibilities, which we'll come on to later. So certifications and standards are going to be really useful to allow business to show that they are compliant and to help them become compliant. So things like developing methodology, organizational measures, technical requirements, standards and certifications can help businesses with that and try to ensure that they can demonstrate compliance to regulators.
Brilliant. I mean, I'm sure there's a lot of analogies about carrots and sticks, which we could apply here, but very much this morning, whenever you shared these slides, was the first time I'd seen that diagram in that format, and it really does help to sort of show that this is not a one shot, one problem, one solution. This is part of a wider strategy, and it's somewhat reassuring to see that. So thank you for that piece of detail. It's very helpful. Anna, if I could ask now, Keith just mentioned products with digital elements, or PDEs, which is the acronym that's been thrown around. What does that actually mean? I mean, what is it? What does it apply to?
So the Act defines it as a software or hardware product and its remote data processing solutions. But I think it's helpful to put that in context of some real world examples. So we've tried to do that on screen, but this is a very small list of examples. I mean, the range of product that are going to potentially be caught by this Act is absolutely huge. You'll see there, smart wearable technology, baby monitors, laptops, mobile phones, VPNs, password managers, firewalls, a whole range of really different products are going to fall under the scope of this Act. It's important to note as well, though, that there are specified exclusions from the Act, and these are things that the institutions feel are adequately regulated elsewhere through other legislation. Examples of that would be, medical devices, motor vehicles, and products that have been developed or adapted exclusively for national security or defence.
Brilliant. And when we chatted earlier, we realised that an awful lot of people would be surprised at exactly what this will include or can include. And we gave some examples where, for example, there are smart connected salt shakers, these smart connected toasters, which by many are looked at as junk devices, but those things will be impacted by this, literally everything. Do you think that this might have some impact in limiting the number of, you might also call it, junk devices which have connectivity for no reason? Do you think that'll help in curbing sort of e-waste and that sort of element?
Yeah, I think absolutely. I mean, there's going to be a compliance cost associated with making sure that your products comply with these requirements of the Act. And I mean, it's sort of a cost benefit analysis at that point needs to be carried out. What can we sell these products for monetarily versus what's the compliance cost here? Is there room for profit?
Yeah, understand. Okay, Keith, if I could ask then, so in terms of the application of this law, who does it specifically apply to within the supply chain?
Yeah, so the Act itself uses the term economic operators. Whenever you see that term within the legislation, it really catches manufacturers, authorized representatives, which are individuals who've been appointed by the manufacturer to represent it within a particular country within the internal market. And it also applies to importers and distributors. So quite a broad range of entities there. And it does catch various levels of the supply chain, which is a new position, I think. And it's not sufficient for an importer or distributor to sort of sit back and rely on what the manufacturer has done, they have now got obligations themselves. They need to make sure that the product that they're importing or distributing into the internal market complies with the CRA, and indeed there'll be penalties and enforcement options if they fail to do so.
That's just as you're saying that, and not to try and throw hard questions, but does that cause a problem if, for example, a company has built a device and that device has significant elements of it based on open source software? Because that's something that's very, very common. People will build their product around a core of sort of open source. Does that mean that this applies to open source? And that's almost difficult because open source isn't a supply chain. It's sort of a subscription, if that makes sense. How does that work?
Yeah. So open source was one of the thorniest issues for the European Commission to deal with whenever the legislation was being drafted. And the open source community, quite rightly, lobbied the European Commission to get their position represented because, as you say, so many of these products incorporate elements of open source software. And I've been tracking it online, and it does seem to be that the final text has been broadly supported by the open source community. There's been a number of exceptions and exemptions put into the legislation to try to protect their rights and to try to protect their industry, because it's recognized as a useful and necessary industry as part of the development of these products. And so, the final text says that only free and open source software made available on the market and therefore supplied for distribution or use in the course of a commercial activity should fall within the scope of the regulation. So it's that wording, commercial activity, which I think is going to be key here, Ben, and it's going to be debated probably in future. And the European Commission has preempted that by saying that we understand this, and there's going to be guidance published on that, Ben. So I think that this is a space to watch, but I think on the whole, certain elements have been excluded. The other really interesting point about open source is that the Cyber Resilience Act has introduced a new concept of an open source software steward. And that is defined as an individual who provides support on a sustained basis for the development of a specific PDE incorporating open source software. So if you like, they're kind of like a dedicated guardian for a specific open source software within a product. They're tasked with maintaining it, for example, keeping it running smoothly. And the legislation says that they will be subject to a light touch regulatory regime only. And the financial penalties that we'll talk about in a minute won't apply to them. They will have some obligations. They'll be required to cooperate with market surveillance authorities and so on. But it's much more of a light touch approach. And I think the general consensus for the open source community is that this is a sensible balance and actually could help to support the open source community by giving it recognition of the role that it provides and showing that they can be and are responsible players within the software landscape.
I can understand that. I mean, speaking as someone who contributes to open source, I do it because I want to help. I do it because I want the things I write to be useful for other people. But it could put a lot of people off if every time you want to help people, you have to fill out a form. That'll kill open source pretty much overnight. So it's good to see that they recognize that. On the other side, speaking of the risks, it's also very, very valid. Recently, there was a zero-day vulnerability which was traced back to literal infiltration of the open source group or team that made the software, and they were infiltrated over a course of 2 years, and someone built backdoors into the open source software for a Linux utility that's in everything. So it's not that there's no risk, it's just that we don't want to kill the open source contribution market. Perfect.
Yeah.
Brilliant. Okay, so in that case then, where specifically does this apply to along the length of the supply chain? And in terms of regions and in terms of areas?
Yeah, so this is a piece of EU law. So it's going to apply automatically. Once it becomes law, it'll apply in all of the 27 member states of the European Union. Those member states don't have to do anything additional. They don't have to enact their own law to implement it. It just applies automatically. And so, yes, it just takes place. But the thing about it is because it's dealing with the product supply chain, and because a lot of these products are designed for the international market, businesses are going to feel the effects of this outside of the European Union. So, for example, if you're a business in the UK, you're manufacturing products, possibly like the one you're doing at the minute, Ben, you're going to be interested in the CRA because presumably you'll want your product to be available to customers and businesses within the European Union. So really, in a sense, it's a bit like GDPR. Whenever it came into play, it increased the standards for everybody because data was portable, it was transferable, and these products are transferable and designed for international use. So I think it's going to become the golden standard, whereby businesses, manufacturers, importers are going to be seeking to comply with the CRA to keep their options open to make sure that they are not limiting the markets in which their products can be sold.
Brilliant. Yep. Understood. And again, it is a thing of concern, and also with thanks to Veronica, who'd asked a question about whether this applies to the UK, and hopefully that answers it. And then I know we're going to speak a little later about more details and UK legislation. Brilliant. Now, again, with the difficult questions, we're in Northern Ireland and we're in a somewhat interesting situation with regards to one foot in, one foot out from Europe. Obviously, it's difficult to speak definitively across every case, but what does Northern Ireland's position look like in this? Where do we sit?
Yeah, so Northern Ireland is in a bit of an unusual position. So there's a piece of UK legislation, which we're going to talk about in a minute, which is quite similar to the Cyber Resilience Act, but it actually expressly carves out Northern Ireland because of the Brexit deal that has been agreed. But the general principle is the same, that if you're a developer, if you're a business manufacturer in Northern Ireland and you're looking to export your product to Dublin, to Germany, to wherever it is, you're going to be looking to comply with the Cyber Resilience Act, because without that, you're not really going to be able to export that product. So in practical terms, whilst there's a bit of legal nuance and lawyers get very excited with this sort of thing, in practical terms, if you're a business, if you're a manufacturer, developer, you're going to be looking to comply with the Cyber Resilience Act and also the UK Act as well, if you're looking to export your product into the UK.
Sure, understood. Okay, so one thing I know we want to talk about in quite some detail is really, what does this mean? What are the obligations for organizations who are either involved in supply chain or product design or delivery or any part throughout this? What do people actually have to do? So very much handing over to yourselves to take us through the detail of this.
Certainly, thanks, Ben. I think one thing to sort of preempt is that some of the obligations are going to depend on what class your PDE falls into. The Act classifies PDEs by reference to the sort of cybersecurity risk associated with the product, and the risk of, what would the impact be if something goes wrong. It divides them into certain categories, and we have sort of default, important, and critical. And we'll not delve too much into the detail of that at the moment, but it's something to bear in mind that your sort of conformity assessment, which we'll touch upon, will depend, and the burden of that will change slightly depending on what class your PDE falls into. But if we go on now to speak about the headline obligations imposed by the Act itself, if we take design as the first one. So it's sort of a principle of cybersecurity by design. And what that means is that when you're designing and planning a product, you really need to have the cybersecurity elements of it at the forefront of your mind at all times. This product needs to be put onto the market with appropriate cybersecurity protections based on the risks associated with the product. And so the Act does give examples of things that you need to think about, and that's contained in Annex 1, I believe, of the Act. Some examples would be the product needs to be secure by default configuration, and there needs to be an ability to reset the product back to its sort of original settings. You need to think about, do I have the ability here to patch or address vulnerabilities that arise? Do I have protection against unauthorized access? And when it comes to the data involved in the PDE, you want to think about encrypting that data, or the principle of data minimization. And what that means is only process the data that you actually need for the intended use of this product. So there's various things that need to be sort of thought about in the design process, and it's a sort of a cybersecurity risk assessment that then needs to be carried out, and Keith will touch upon that.
Yeah, so the assessments is quite a big part of the Cyber Resilience Act. the very first one that manufacturers are going to have to do is this, what's called a cybersecurity risk assessment. And that starts, as Anna said, right at the very beginning of the product life cycle. So the risk assessment, Article 13 says it should consider the planning, design, the development, the production, the delivery, and the maintenance phases of the product in question, with a view to minimizing cybersecurity risks. So sort of a full life cycle risk assessment that has to be done. And it can't just be sort of a template document. It can't be sort of a one size fits all. It has to be specific to the product in question, to the operational environment that's intended to be used in, to the intended use, and to the assets, if any, that are to be protected by the product. So it has to be quite specific. And I think that's probably quite an onerous obligation on manufacturers. Once the product then is ready for market, then a conformity assessment has to be carried out. And that is really just to step back and assess, right, does this product as developed, does it conform to the EU regulations? And once you've done that, once you're happy, then you sort of have to nail your colours to the mast, and you have to produce what's called a declaration of conformity. And that's really you saying that, yeah, we've satisfied ourselves that this product does conform to the CRA and any other regulations that apply to it. And you have to include things like the name and address of the manufacturer, and you also have to put on the CE mark to indicate that you've checked the product and that it complies. So quite a number of obligations there on the assessment front as well.
And then moving on then to the support obligation, and this is a really significant one, and there's been a lot of talk about it. The obligation to provide sort of cybersecurity support applies for the lifetime of the product. And that has to be at least 5 years unless the expected lifespan of that particular product is less than that. So what that means in practice is that manufacturers will have to continue to monitor products that have been released onto the market and release free updates and patches for any vulnerabilities that arise.
And then moving on to reporting, you have to continue to report any vulnerabilities that you become aware of, and you've got a very strict timescale to do so. You have 24 hours to report any vulnerability or incident which you become aware of, and then once you've done that, then you have an obligation, depending on the severity of that vulnerability or incident, to keep the authorities informed as to what you're doing, what mitigation steps you've taken, and whether the incident has been resolved. One useful piece that's come out of the most recent draft of the legislation is that there's going to be a newly created platform to submit these reports. So there's going to be like a one-stop shop for doing it. So you don't have to go around every individual member state and find the Market Surveillance Authority and make your report. You've got a one-stop shop, which is going to be run by the EU Agency for Cybersecurity. So that looks like it's going to be an online portal where you can upload details of any security threat that you've become aware of. But your reporting obligations don't stop there, unfortunately. You've also potentially got to inform users of the product itself. If you become aware of an incident that might affect them, you've got to do that in a timely manner, and you've got to suggest steps that they can do to mitigate the impact of that incident or vulnerability on them. And then in very limited circumstances, it might be that the public at large needs to be informed about an incident or a vulnerability as well. And if that's the case, then you would be working with the EU authorities to do that, and they would probably do that on your behalf. So reporting, again, big obligation, and there's various layers within that as well, depending on the severity of the incident or the vulnerability. And that then ties in very... Sorry, go on ahead.
Apologies, sorry. No, I was just going to say, folks, get in a few messages from the chat. We will be answering questions afterwards, so don't worry, we're going to come to some of those already. So apologies. Sorry, Keith.
Yeah, no problem. I was just going to say that actually leads on very closely into the communication point. Throughout the legislative process, the European Commission made it very clear that they didn't think that manufacturers were communicating smartly or well enough with end users. They felt that it was being the way that communications were being drafted was not in a way that end users would particularly understand, weren't adapted to the types of end users that were expected to use the product. So they've addressed that, and they've put quite a heavy responsibility on manufacturers to communicate well and succinctly with end users. So for example, the manufacturer's details must be made available to end users, their name, their address, contact details. There must be a single point of contact for end users to report any vulnerabilities that they become aware of with a product with digital elements. And they must also provide instructions on the secure use of the device itself. And that includes everything from how to set the device up, how data can be removed securely whenever the device is being decommissioned, and how updates are going to be applied to the device as well. So that there's an obligation there to provide good instructions and clear instructions. And the overriding theme from the European Commission is that in each case, this information has to be provided, to use their words, in a language that can be easily understood by users and market surveillance authorities. So, technical language might be suitable for one type of user, but it might not be suitable for another type of user. And you have to take that sort of nuance into consideration as well.
Brilliant. Folks, just we are aware that in terms of time, we've about 15 minutes left and we want to leave some time for questions. So without, I don't know what the term would be, incriminating myself, asking a little about penalties. What happens if people don't comply? Not that I have any intention not to comply.
Well, it's fair to say that the potential penalties here are very significant. It could be up to 15 million euros or 2.5% of annual world turnover for the entity, whichever is higher. So, the regulator really has, I think we discussed it earlier, sort of teeth when it comes to this, but there are also other things that they can do other than, a monetary penalty.
Yeah, so enforcement's another part of this. So yes, you've got the monetary side of things, but they also authorities have significant powers at their disposal now, things that they didn't have before. So each member state will have to set up what's called a market surveillance authority, and they will be tasked with checking that businesses within their country comply with the Cyber Resilience Act. And each one of those, each market surveillance authority will have the ability to take what they call corrective measures. And that includes things like asking the business, the manufacturer, to bring the device into conformity, to withdraw it from sale if necessary, or to issue a product recall. And they can also coordinate with each other. So these market surveillance authorities within each country can coordinate with each other and conduct what they call simultaneous coordinated control actions or sweeps. And that could be where they work together to investigate a particular sector, a particular type of product, to see if they are in compliance with the Act. So these are very wide powers. And the European Commission will also have a central role in enforcing that and monitoring how each market surveillance authority is operating as well, to ensure that the Act is being followed. In relation to the UK positions, the question we're often asked is, well, that's all very well. Those market surveillance authorities are situated in the EU. How does that affect us? And I think it does, because if you're looking to sell your product in the European Union, well, then that market surveillance authority for each of the countries that you're selling your product will be looking at your product. They'll be looking to make sure that it complies with the Cyber Resilience Act. And if it doesn't, they can escalate it up to what's called the Union Safeguarding Procedure, which essentially is it's a body that's been established by the European Commission to look at compliance as a whole, and they can then target individual manufacturers and so on that are not complying with the regulation. So you could find yourself, for example, not being able to sell within the internal market if you're not complying with the regulations.
Brilliant. That's good to hear, and I think we've covered some of the questions which are in side channels. But just to jump on one in particular, this is Robert's question. Do you think there's opportunity for local business here to actually support these kinds of actions? So we already have penetration testing for the more cybersecurity core. Do you think there's opportunity for businesses to support other businesses in these kinds of actions to comply with CRA?
I think undoubtedly so, yes. I mean, you'll see the sort of industry that was created whenever the data protection regime was implemented. There are whole businesses out there devoted to advising businesses on how to ensure their GDPR and Data Protection Act compliant. So I can definitely see something similar happening here. And again, perhaps organizations, you mentioned pen testing, organizations might hire an outside organization who are experts in the CRA to come in and sort of test their products and give them guidance on where they might not be up to scratch and what they need to do to get there. So definitely there are opportunities going to arise out of this act.
Brilliant. And have you maybe got a case study or an example you could take us through?
Yes, absolutely. So we'll just touch on this very briefly. If your company wanted to manufacture a smart doorbell, which obviously will record images and sounds, and there'll be software involved in using that, what are the things that you would have to think about? So going back to the sort of design piece, cybersecurity needs to be at the forefront of your mind from the very inception of this product. You need to have your mechanisms inbuilt within the product to ensure that it's sort of CRA compliant, preventing unauthorized access and so on. You then need to think about your technical documentation. Do you have everything that you need? Have you done your cybersecurity risk assessment, your conformity assessment, and related to the conformity assessment, what class do you think this falls into? Can that be a self-assessment piece? Do you need to involve a third party standard there? You need to include all of that in your technical documentation, as well as your declaration and so on, all in easily understandable language. And then finally, the life cycle piece. How long do you anticipate the life cycle of this product being? And are you in a position where you can stand over it and provide those security updates to patch any vulnerabilities that might arise? And of course, if there are incidences, you need to then be aware of your reporting obligations and the potential penalties and actions involved in that.
That's fantastic. Thank you. So as we sort of bring close to a close, something which was mentioned earlier, and something we're very aware of is the UK's PSTI Act. Keith, could you maybe give us an overview of how CRA will interact or overlap with that?
Yeah, and this is one of the outcomes of Brexit, where we have regulatory divergence now between the European Union and the UK. Previously, the CRA would have applied to the UK, but now we're seeing the UK sort of forge its own path. But I think the key message is, or the key thing is, that both legislators are trying to solve the same problem. They both recognize the risk that these products are causing. And actually, when you stand back and look at the two pieces of legislation side by side, there are significant similarities between the two. The UK's version, the snappily entitled Product Security and Telecommunications Infrastructure Act, came into force in the UK on the 29th of April of this year, so it's quite fresh as well. But when you look at them, the application, the CRA refers to products with digital elements. The UK version refers to relevant connectable products. There's some exceptions from that as well. Some of those are the same: medical devices, some exceptions around cars and EVs. And the requirements as well are strikingly similar. You've got reporting obligations, you've got record keeping, you've got the obligation to communicate well with end users, minimum support periods. A lot of those things are quite similar across the two pieces of law. And equally, both the UK and the EU take this very seriously. Penalties are steep and enough to make, I think, manufacturers sit up and take notice. And then the enforcement piece as well, very, very similar. The idea, they're trying to solve the same problem. If you've got a product which is not secure, that is potentially vulnerable, you need to get that product sorted out. You need to fix it or get it off the market. So they're both trying to solve the same problem, and it's not surprising, therefore, that actually the two pieces of legislation look quite similar. In terms of how that plays out for us in the UK, I think we just have to approach it that, yes, there are these two pieces of legislation. We do need to make sure that we're complying with both of them. But actually, I think if you're complying with the Cyber Resilience Act, you're probably pretty much there in terms of complying with the Product Security and Telecommunications Infrastructure Act as well. There are some differences, but actually the two pieces of legislation do complement each other quite well.
I'm sure there's a lot of people who are quite happy about that, myself included. Okay, as we start to bring it to a close, I want to leave some time for questions. So Anna, Keith, if you were to just sum up in 30 seconds or 60 seconds, where does this leave us? What are the big takeaways?
I think that one of the key takeaways for me is the importance of being prepared here. We touched upon it earlier. 2027 is actually not that far away. So be prepared. This is an evolving sort of situation. It's not yet in force. Guidance will follow, and just keep an eye on things and reach out, I suppose, if you need advice. We're working alongside Simon and the team at Vertical Structure on sort of articles and information pieces. So just keep an eye on LinkedIn for those, because as the Act progresses through the process, and we learn more about it, we'll be sharing that information.
Yeah, and for me, Ben, I think this act represents a sea change in approach. We're moving from a position where companies were taking their own path. We've now got a consolidated approach, and we're moving from an area where there wasn't much regulation to one where there's actually quite heavy responsibilities and obligations imposed on entities right down the supply chain. So it's a very different environment that we're moving into. And as Anna said, yes, be prepared. We're going to have new practices, new procedures to adopt, and to be aware of. Regulators will have new powers and will be able to impose significant penalties. But I'd like to sort of finish on a positive note. I actually think that this legislation can have benefit for businesses in Northern Ireland and across the UK, particularly those businesses that have been trying to adopt good cybersecurity practices all along, because now I think this levels the playing field, and it maybe makes it a slightly easier market in which to do business, and it will reward those companies that have adopted that approach to date, and hopefully in the process actually make some of these products more secure for all of us.
Brilliant. Anna, Keith, I'm going to jump straight into questions, and just looking through the list, I think we've in the discourse we've covered the questions by Veronica, by Andrew. We've covered one of Sean's. I think we've covered Robert's, but I'm going to jump back to one of Sean's questions, which is there a potential issue in getting products manufactured in China where the manufacturing chain, along with other supply chains, cannot be easily validated and may have state-level interference?
Yes, is the short answer to that, potentially, because you need to, if you are putting the product on the market, you need to stand over it. It'll be you making those conformity declarations and so on. So you could come up against practical issues, but a level of due diligence will be expected to be done on the supply chain involved.
Yeah, I think that's right. I think the obligation, if you're an importer or distributor, you have to do your due diligence. You have to understand where the various components of the product are coming from. If there's a SaaS element, you need to understand that aspect as well, because you need to understand where the data is being stored. So yes, this does represent a change, and I think that, you know, with a lot of these products having components coming from China, yeah, that there's going to have to be a new level of scrutiny imposed on those parts that are coming from there and across the world.
So good news for European component manufacturers.
Yeah, potentially. Yeah.
Okay, going to take one more question just from Joseph in the background, and it's asking how do we best keep updated with what's going on with this act as it comes into force?
One of the things, it is evolving, it is changing, and the European Commission has said that there will be guidance published in due course. What I would recommend is, if you want to follow us on LinkedIn, would be one way to do it. We're sort of monitoring the development. We're sort of active in this space. So if you follow myself and Anne on LinkedIn, we will be publishing updates and guidance as this evolves. And you can also look at the European Commission website as well, because they will be setting out that guidance as well, and setting up things like the market surveillance authorities and so on. So there's lots of material out there. I think actually the trick is trying to distill it to the bits that are relevant to you, and that's part of our job, is trying to make sure that the information is concise and is accurate and is relevant to the UK and the Northern Irish market.
Brilliant. And Keith, I think that's us just hitting time. I want to say thank you so much to both of yourselves and everyone else at ALG for supporting us and giving us all this fantastic information in this webinar. I want to also say thank you to Gillian, to Joe, and the rest of the team at NI Cyber for putting this together. I would encourage everybody to follow through, and yes, like, share, subscribe on your LinkedIn and other social medias. And likewise for NI Cyber, please do like, share, subscribe, and follow us. And then you'll see other events such as this in the Lunch and Learn series. And would then also like to remind, we have quarterly tech and tipples events and our monthly breakfasts last Thursday of every month, jumping between CSIT and one of our member venues. Folks, thank you very much. I hope everyone has a great end of their week and weekend, and looking forward to a more cyber resilient future. Thank you.
Thank you very much.